Emergency action is one thing. Acting outside the law is another. The Auditor General says the procurement crossed that line. Vaz says he had no choice. So before the arguments, the think pieces, or the outrage, I'm going to grab a cup of coffee, sit back, and listen to what he actually said.
I make no apology whatsoever. As a matter of fact, I go further. In circumstances such as these, if I had to do it again, I would do it again.
I wish to point out further that the issue is complicated by the minister's own public statements. On November 1, 2025, Minister Vaz announced that Jamaica had received 700 Starlink units as a donation in the aftermath of Hurricane Melissa, presenting the devices as emergency support for national connectivity. Jamaicans are entitled to clear and consistent answers. If 700 Starlink units were declared as a donation, the public must now be told why a subsequent purchase has been made and now been flagged by the Auditor General.
In response to the opposition statement, I simply say to Philip Paulwell, the leader of the opposition, all members of parliament in the affected areas, both opposition and government, plus mayors and councillors on both sides were recipients of Starlink to allow them to be able to better communicate with the responding agencies and their constituents. So I'm not quite sure what they are complaining about.
Once you listen carefully, the contradictions don't jump out loudly. They show up quietly, in the details. Take the emergency argument first. Vaz says the situation was urgent. Communications were down. Action had to be taken immediately. And that makes sense. Emergencies don't wait. But here's where the story starts to bend. If this was a lawful emergency procurement, why were key procurement documents completed after the equipment had already been delivered? Emergency procedures still require paperwork. The difference is speed, not order. Paperwork can be fast. It's not supposed to run backwards. Urgency explains speed. It doesn't explain backdating. Then there's the claim that he had to step in, that leadership was required in the moment. Again, leadership during a crisis is expected, but the law draws a clear line between leadership and legal authority. Under the Public Procurement Act, procurement authority sits with the head of the procuring entity, not a minister. Ministerial direction initiating procurement is restricted, even in emergencies. In other words, you can lead without stepping into a role the law assigns to someone else. Leadership isn't the same thing as legal authority. Vaz also points to emergency procurement guidelines, saying they allow flexibility in times of crisis. That's true, to a point. But guidelines don't override the law. They operate within it. Flexibility changes the process, faster timelines, fewer steps, but it doesn't change who is legally allowed to act. A guideline can bend a rule. It can't erase it. Then there's the issue of need versus use. We're told the Starlink devices were urgently needed to restore communication. But the audit found that some of those devices were still unused or sitting in storage months later. If the need was immediate and critical, why wasn't deployment immediate and complete? Urgency usually leaves fingerprints. Storage doesn't. Finally, there's the response itself. Vaz makes no apology and rejects the findings outright. Even if we assume good intentions, the question remains, why not acknowledge procedural weaknesses and commit to tightening them? A total rejection suggests the process was perfect. The documentation suggests otherwise. Defending intent doesn't answer questions about method. And that's why this isn't really a debate about Starlink. It's about urgency, authority, and whether emergency quietly became exemption. As always, we're just laying out the facts and the public record. No party colors, no political allegiance, just information. So you can decide for yourself. Thanks for watching.